Williams have inferred that the Second Amendment did not provide an absolute individual right to own or possess a firearm. Adam versus Williams, 1972, stated, there is no reason, quote, there's no reason why stiff laws may not be enacted or require a purchaser to pass a psychological test. And a former conservative Chief Justice, Berger, said that, quote, if an 18th century militia was intended to be well regulated, surely the Second Amendment does not remotely guarantee every person the constitutional right to have a Saturday night special or machine gun without any regulation whatsoever. So it's pretty obvious that the phrase right of the people to keep and bear arms cannot simply and only be interpreted to mean the absolute and unrestricted right of an individual to possess and own any and all arms. And this is not the holding of the Supreme Court in the Heller case. The Supreme Court in Heller, 2008, held that the Second Amendment guarantees an individual's right on federal land to possess a firearm unconnected with service in a militia and to use that weapon for traditionally lawful purposes such as self-defense of one's home. The case is limited to its federal jurisdiction and involves only residents of the District of Columbia who were not simply subject to gun regulation, but were prohibited from owning handguns at all, except for a grandfather clause that continued ownership established before 1975, but required that such guns be unloaded, disassembled, or trigger locked. However, Justice Scalia wrote the court's decision and said that it, quote, should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws imposing conditions and qualifications on the commercial sale of arms, end of quote. The court concluded that the Second Amendment is, however, not a collective right, or no longer a collective right, some of us might say, but now, as a result of the 5-4 decision, an individual right tied to the natural right of self-defense. My final thoughts then would be these: recognizing that the militia no longer exists, but that standing armies in peacetime and warfare and professional police forces, the National Guards do not these considerations allow for and call on limitations in gun use rather than a more permissive privatization? Even more so, it would seem, when one considers that this country leads in the number of murders per year as well as the number of those imprisoned yearly. In summary, the right was a collective one early on and continued that way until a 5-4 majority in Heller declared the right to be individual. So everything has changed, but really nothing has changed. The right has never been an absolute one. None of the Bill of Rights are absolute. No right can be absolute and only fundamental because we must consider everybody else's rights in juxtaposition to one's right. So that if one person had an absolute right, then other people wouldn't have an absolute right. It is a fundamental right, guaranteed, and then interpreted in the facts of the case by courts and through legislation. The right has never been an absolute one, even when it was considered collective. And all of the Bill of Rights are subject to regulation, whether the right is individual or collective. When the right was collective, individuals, nevertheless, could find redress in the courts for its violation against them. And now, with the right as individual, nevertheless, governments and courts are free to enforce constitutionally valid regulations. The American constitutional system is an ingenious philosophical invention, wish it had worked that way, of political experts such as Montesquieu, Locke, Mason, Jefferson, Madison, and others, constructing a federal system of separation of powers and checks and balances derived from the natural law and social contract, and calling for the equitable rule of law of rights and duties for all citizens of this country. Let us never cease to follow that call and implement it accordingly.